In this era of mass incarceration, we need to learn a little bit more about the mitigation arc. My name is Michael Santos, and that's what I'm going to be describing today. This is an article that we're featuring on our website at prisonprofessors.com. If you want to download the article itself, just go to the top tab and you will see a section that says resources. And on that resources tab, you will see a drop-down menu with a tab that says advocacy. And I want you to download the article that we call Understanding the Mitigation Arc. I wrote for people because I know a lot of individuals going into the system don't really understand how crucial it is for them to make good decisions at every stage in the journey. So let's go ahead and read the article. For those of you who are watching on YouTube or listening on iTunes, you can follow along on YouTube, of course, by the video. But on iTunes, you could also listen. But I would encourage you to go to the website itself and download the PDF or visit the page. Again, that's at prisonprofessors.com. So here is where we're going to start reading. Understanding the Mitigation Arc. In this article, we offer insight with hopes of helping people along the mitigation arc. Regardless of what stage of the journey they're in, it is never too early and never too late to prepare for a better outcome. For this reason, we urge all justice-impacted people to think about the mitigation arc. Our daily decisions open opportunities for higher levels of liberty at an earlier time. And here's the author's note. I am Michael Santos. The information I offer through this article comes from lessons I learned while going through more than 26 years in federal prison, from my research and from interviews with more than 1,000 justice-impacted people. Those include defendants and people who concluded sentences in federal or state prison. The daily research consists of the study of policy statements and interviews with U.S. attorneys, federal judges, a retired director of the Bureau of Prisons, a former administrator of the BOP Halfway House program, and a retired chief of U.S. probation. Visit our subject matter expert page at Prison Professors for more. Although I use the pronoun him throughout the article, the information applies to both men and women. So here are the 5 early stages of the mitigation arc. Learn how the decisions at every stage of a mitigation arc influence a person's ability to advocate for a better outcome. And the 5 stages include the first stage, which is the charge, the second stage, which is the plea or the verdict, the third stage is the pre-sentence investigation report, the fourth stage is the sentencing hearing, and the 5th stage of the arc is post-sentencing. So, first stage of the mitigation arc, let's discuss the charge. In earlier writings, I have paraphrased a question I heard in a speech. The speaker asked his audience the best time to plant a seed for an oak tree. People didn't know how to respond. They guessed. After the speaker's dramatic pause, he told the audience that the best time to plant a seed for an oak tree was 20 years ago. The second best time would be today. The analogy conveys the importance of early preparations. If we had made different decisions 20 years ago, we'd all be in a different position today. And with that end in mind, it is clear that decisions made today influence opportunities that open for us in the weeks, months, and years ahead. Regardless of the stage, at the start of a journey, during a prison term, or after transitioning to supervised release, we can learn by reflecting. Self-advocacy training requires us to open our eyes and seize or create opportunities to advance our prospects for success. We'll follow Jim's story to understand the mitigation landscape at the first stage of the mitigation arc. Note that Jim isn't a real character, just a name I chose to help readers understand one person's progress through each stage of the arc. Had Jim understood the system early, he could have architected the best strategy for his circumstances while going through the criminal justice system. Jim could have made the right decisions at the right time. In this context, I am defining the right decisions as the type that would not have exposed Jim to interest from either civil or criminal law enforcement agencies. The more Jim knew, the more capable he would have been at protecting his liberty. The day Jim learned that law enforcement officers considered him a potential witness, subject, or target of a criminal investigation, Jim should have begun architecting a mitigation strategy. At this first stage, Jim would need to research defense attorneys. What type of defense attorney would suit him best? The cost of hiring a competent criminal defense attorney may surprise some people. Becoming a skilled criminal defense attorney requires an investment of thousands of hours in training and practice. The defense attorney practices his profession. After graduating from law school, he may work in a series of relatively low-paying jobs to gather more experience. He may work as a clerk, a civil servant, or an associate for several years while managing student loan debt. Once a defense attorney sets up a practice, he may try to recover his investment. A top criminal defense attorney in the federal system with specialized skills may charge more than $5,000 per hour. A moderately priced criminal defense attorney would bill more than $400 per hour. Jim should consider the costs when going into the mitigation arc's first stage. It is as if Jim is going into war. He will need to choose which battles to fight. He will need to consider whether he has the resources to go the distance. Jim can work with a public defender if he doesn't have the financial resources. But Jim shouldn't think about how he can help the public defender advance his prospects for success. Nothing will change the past. But Jim's decisions in the first stage of the mitigation arc will open opportunities for leniency or expose him to gradually increasing sanctions. Some of the best possible outcomes at the first stage of the mitigation arc would be for a defense attorney to accomplish one or more of the following goals. Persuade prosecutors that Jim didn't violate the law and didn't have any knowledge of anyone else who broke the law. Persuade prosecutors that Jim should qualify for a non-prosecution agreement. Persuade prosecutors that Jim should qualify for a deferred prosecution agreement. Persuade prosecutors to offer Jim a pre-indictment charge with a lower statutory cap. Persuade prosecutors to recommend a sentence that would not include incarceration, with a pre-indictment charge that may consist of a financial sanction, probation, or home confinement. Persuade prosecutors to offer a pre-indictment charge with a recommendation for leniency at sentencing, or persuade prosecutors not to publicize Jim's involvement in the criminal justice system. Succeeding at the first stage of the mitigation arc requires advanced planning. Some factors may be beyond Jim's control. In some cases, powerful political factions influence how prosecutors bring charges. Either way, Jim bears the onus of preparing. If Jim missed an opportunity to get a great outcome during the first stage of the mitigation arc, he would advance into the second stage. So here are some questions to guide people at this first stage of the mitigation arc. In what ways have I prepared myself to hire the right criminal defense attorney? 2. In what ways have I prepared myself to qualify for a non-prosecution agreement? 3. What steps am I taking to learn how the criminal justice system operates? You see, the more thought a person puts into the system, the more a person realizes, wow, I should have been preparing a long time ago. But it's never too early and it's never too late to start preparing. And that's where we go to the second stage of the mitigation arc, the plea or the verdict. Prosecutors may choose to bring Jim into the system in one of two ways. They may offer Jim an opportunity to plead guilty to a lower charge through a criminal information or a criminal complaint, or they may convene a grand jury and ask the grand jury to indict Jim for a crime or a multi-count indictment. At each stage, prosecutors become more vested in getting the outcome they want. Once they decide to bring a charge, they want to win. In theory, they are after justice. But for many prosecutors, winning means getting a conviction, not necessarily justice. As I have written previously, anyone going into the system should learn from the wisdom that two philosophers offer. Socrates, who told us we should know thyself. Sun Tzu, who told us to know thy enemy. The inexperienced defendant may delude himself into believing that the prosecutor will view him as a good person. In reality, that's just a sign of ignorance of the system. The prosecutor and every other stakeholder in the system strive for an outcome. The more time passes, the more likely prosecutors and other stakeholders will want a conviction with a severe sanction. They define success by convictions and sanctions, not by seeing defendants as good people. For this reason, everyone in the second stage of the mitigation arc should begin thinking about the challenges ahead. When Jim moved into the second stage of the arc, he missed the opportunity to mitigate at the earlier stage. Decisions Jim makes in the second stage will influence what happens at later stages. Making a good decision in the second stage requires Jim to use the same strategy and tactics that lead to good decisions in other areas of life. A person must define success as the best possible outcome. A person must create a plan and set priorities. A person must develop tools, tactics, and resources that will advance the goal. A person must execute the plan. If Jim pleads not guilty to the charge, the prosecutor will attempt to prove the case through a trial. If Jim agrees to plead guilty, the prosecutor may agree to offer favorable terms in a plea agreement. Jim should understand the costs of proceeding through a trial. In federal court, a defense attorney will want to invest considerable resources to prepare before a jury trial. That could mean reviewing every email, interviewing witnesses, and going through all the evidence that the prosecutors have built against Jim. The time commitment could mean thousands of hours. For this reason, a person should consider the financial costs of proceeding through trial, which could easily exceed $300,000 for a jury trial in federal court. If Jim qualified to proceed with a federal defender, he should question how much time the federal defender would have to prepare for a trial. In addition to financial costs, Jim should think about the risk. If members of a jury acquit Jim, he may move on or he may adjust. If a jury returns a verdict of guilty, on the other hand, Jim will face complications at sentencing. Typically, judges impose harsher sentences when juries return guilty verdicts. A mitigation strategy after a jury verdict would differ from a strategy for a person that entered a plea agreement. I should say it differs from one to the other. The prudent person would consider all options during this second phase of the mitigation arc, considering the earlier decisions. Some questions to guide decisions at this stage follow. What financial resources do I have to defend myself against the charges? What human resources can I draw upon to support me through this challenge? How much time have I invested to learn the landscape of this process? So now we go to the third stage of the mitigation arc. This is the third of 5, the pre-sentence investigation report. If a jury acquits, the person may or may not succeed in putting the first 2 stages of the arc behind him. In other cases, collateral consequences follow that derail a person's prospects for success. Consider the O.J. Simpson trial. He prevailed with an acquittal, but his life never returned to normal after the accusations against him, even though a jury acquitted him. Criminal charges can change a person's life. If Jim pleads guilty or members of a jury vote to convict him, he advances into the next stage of the mitigation arc. From the system's perspective, he changes from being presumed innocent to a convicted felon. After the finding of guilt, Jim must prepare for the pre-sentence investigation. A federal probation officer will begin the pre-sentence investigation long before meeting with Jim. The probation officer responsible for conducting the investigation will start with all the preconceived notions from a career in law enforcement. The sooner Jim begins thinking about the probation officer, the more skillful Jim becomes in building tools, tactics, and resources to assist him at this stage of the mitigation arc. Every day, probation officers work with justice-impacted people. Those interactions, over time, influence whether probation officers will trust the people they are interviewing. What does the probation officer already know? Probation officers will understand what prosecutors say. They will know that, at least from a legal perspective, the prosecutor established a finding of guilt. Since probation officers and prosecutors have ongoing collaborative relationships, Jim should consider whether it is plausible that the prosecutor influenced the probation officer's thinking. We interviewed Chris Maloney, who retired as a chief probation officer. In our interview, I asked Chris about the pre-sentence investigation process. When I asked him about his process in gathering information that would lead to the pre-sentence investigation report, Chris spoke about the long hours that went into preparing the report before the probation officer ever met with the subject of the interview. The prudent person would think about the tools, tactics, and resources he could use to influence this third stage of the mitigation arc. So here are some questions. What could Jim create before the mitigation arc to counter any preconceived notions that the probation officer may have? 2. In what ways would Jim's efforts to influence the pre-sentence investigation report open opportunities for him to advocate for himself more effectively at different stages of the journey? And 3. If Jim missed an opportunity to influence the PSR favorably, what steps could he take to influence the next stages? So now we're going to talk about the fourth stage of the mitigation arc, the sentencing. Once the probation officer completes the pre-sentence investigation report, Jim will move into the fourth phase of the mitigation arc. It is time to prepare for sentencing. Jim and his defense attorney may or may not agree with everything the probation officer wrote. Similarly, the prosecutor may or may not agree with the probation officer's writing. Before the sentencing hearing, the defense attorney and the prosecutor may work with the probation officer to amend the PSR so that neither party objects. But suppose the prosecutor, the defense attorney, and the probation officer disagree on the accuracy of the PSR. In that case, the judge will begin the sentencing hearing by reviewing the report. The judge will listen to the prosecutor, the judge will listen to the defense attorney, and the judge may listen to the probation officer. The judge will decide with a ruling, and the ruling will become a finding of fact. After the judge resolves discrepancies in the PSR, the judge will respond to sentencing memorandums and listen to oral arguments from both the prosecutor and the defense attorney. The judge will offer Jim an opportunity to address the court. At that point, Jim is speaking to an audience of one, the judge. Will Jim be ready for that sentencing hearing? Well, if Jim prepared effectively, he would have tools, tactics, and resources to assist him at this stage of the mitigation arc. He would ask himself these questions. What resources have I built to differentiate myself from other people that appear before sentencing? 2. How did my preparations bolster my defense attorney's effort to craft a compelling sentencing memorandum? And 3. How do the resources I created show the growth I have made since the time prosecutors brought me into the system? That leads us to the fifth stage of the mitigation arc, which is post-sentencing. You see, following the sentencing hearing, jurisdiction over Jim may change. If the judge sentenced Jim to probation, he would remain under the judicial branch of government. But if the judge sentenced Jim to the custody of the Attorney General, that means he will transition into an arm of the executive branch of government, the Bureau of Prisons. The defense attorney may or may not stick around to assist Jim through appeals. However, navigating the complexities of the executive branch of government will require Jim to advocate for himself. The Bureau of Prisons does not respond well to defense attorneys. Many policies and procedures prohibit a person in prison from using a defense attorney until after the person has exhausted all administrative remedies. Although the defense attorney may consider his job done after the sentencing hearing, Jim and his loved ones will begin working through the labyrinthine world of imprisonment. To succeed at this stage of the mitigation journey, Jim will need to develop a new set of tools, tactics, and resources. In the first step era, the strategy of building an extraordinary and compelling record is essential. No one should take our word for the importance of memorializing a journey that will advance prospects for success. Instead, the person should visit our subject matter expert page from the resource tab of our nonprofit's website. They will find my interviews with people at the highest levels, including video interviews with 2 federal judges, video interviews with a retired chief of U.S. probation, video interviews with a past director of the Federal Bureau of Prisons, video interviews with the former administrator of the nation's halfway house system. What will all those interviews have in common? Each interview reveals a unified message showing how the system operates. People who build careers in the criminal justice system want to see incremental progress. They want to build a record showing that the system helped the person advance to increasing levels of liberty. Those professionals will rely upon written records. The written records show that the system is working, and it gives validity to the work they are doing. The more Jim understands the system that holds him, the more influential he becomes at engineering a mitigation strategy that will lead to the highest levels of liberty at the soonest possible time. Some questions to guide Jim's preparation for self-advocacy at this stage of the journey follow. What tools, tactics, and resources am I creating to advance my candidacy for the earliest possible transition to liberty? How will I learn from subject matter experts or policy changes once imprisonment separates me from the internet? How am I preparing myself to respond to challenges I may encounter once I transition to an RRC or while I am on supervised release. So here's the conclusion. Every stage of the criminal justice frustrates us. The criminal justice system frustrates us. While going through the various stages, we'll frequently see inequities. People like Jim will see administrators requiring him to abide by rules that they flagrantly violate. To get the best outcome, we need the best resources. We need examples. We need to know how to use the system's mechanisms to self-advocate. As a person that lived in the system for 9,500 days, I make a commitment to show others the strategies that I use to advance myself to higher levels of liberty and to succeed upon release. It is my hope that members of our community will find value in this lesson. So please share the message with others around you. I strive to be the change that I want to see in the world. And that change includes working to bring systemic reforms that you can use to get the highest level of liberty at the soonest possible time. You see, I believe in you, but I know a lot of people just really don't grasp the reality that the decisions they are making today are either going to open opportunities for them in the future, or it's going to close off opportunities, or it's going to put them in a more difficult path. We want people to get the best outcome. That's one of our commitments at this nonprofit, the Prison Professors Charitable Corporation. So please visit us at prisonprofessors.com. And if you're watching this on YouTube or iTunes or anywhere else, please subscribe and pass this information along. If you want to download a PDF of this article, just do so from the website. It's completely free. We are here to serve with hopes of helping to improve the outcomes of the criminal justice system for all. I am Michael Santos, and I want to thank you for being a part of our community.